This is Michael Popok, and by the lighting, it's Legal AF After Dark. What is going on in Georgia with Judge McAfee? We were waiting on an order for him to decide whether to keep thumbs up or thumbs down Fani Willis as the Fulton County DA on a sign to the Trump matter. But instead, we got an order where he just dismissed 6 out of the 41 criminal counts against all co-conspirators in Georgia, getting rid of 2 counts against Donald Trump for now, the big for now emphasis, because of some indictment pleading problems that may or may not be solved by the future prosecutor or the current prosecutor. We break it all down on Legal AF with a former prosecutor, happens to be one of our podcast hosts, Karen Friedman Agnifilo. And here you go. I want to talk about Georgia. So we were expecting that Judge McAfee today, tomorrow, Friday, was going to rule on the issue of motion to disqualify had been brought by Mike Roman and all the other defendants to get rid of Fani Willis and Nathan Wade because they were or are in some sort of relationship, whether that started before the indictment, during the indictment, or after the indictment of Donald Trump, and whether there's an actual conflict of interest or some other standard that he may use to dismiss her from the case. That's the order I thought we were going to get. Instead, we woke up today to an order in which the judge, in 9 pages or less, decided that 6 out of the 41 original counts of the indictment, including 2 against Donald Trump, who didn't survive what's called a demurrer or basically a motion to dismiss under Georgia procedural law, not because the 100-page indictment, which we all have our dog-eared copies of here, not because it didn't have enough detail. It just didn't have enough detail apparently related to one aspect of the standalone crimes against Donald Trump, particularly his phone call, as alleged, to Brad Raffensperger, Gene Sperling, and others with Mark Meadows to try to find 11,785 votes to overturn the will of the people and make Donald Trump the winner in Georgia. That act, what we call an overt act towards the furtherance of a crime, which is at the heart of the conspiracy, which is the framework, the driver for this indictment. But along with the conspiracy count that is still alive and kicking, along with 35 other counts, including the others against Donald Trump, there was also a couple of standalone counts by themselves for crimes committed based on that phone call and that behavior. Those, as of right now, have been kicked by the judge, subject to some other conduct and behavior that Fani Willis or whoever the prosecutor is can use to try to save them should she or whoever's the prosecutor feel the need to. What I want to do, having now sort of framed that, so let me get the headline is all of the overt acts, including those related to the telephone call, remain in the indictment, can be put on as evidence in front of the jury as part of the conspiracy and some of the other claims or counts in the indictment. It's just when they were going to get to the point of instructing the jury about these other additional crimes for that particular act, separate and apart from the conspiracy count, as of right now, the prosecutor wouldn't be able to put on that, have the jury instructed on that, or have the jury find those counts. And look, there's a reason an indictment comes down with lots of counts. I don't want to say it's overcharged, but there's 41 counts in here. It's a lot of counts. She only needs 1 to put the guy in jail. She proves RICO, the guy's going to jail, a guy named Trump, for a long, long time. Now, having said that, there is, and I'll turn it over to Karen, our favorite former prosecutor, to talk about her view of it from an indictment standpoint, from a result standpoint. But rather than have sort of a holy crap moment, like, oh crap, some of the indictment got dismissed, I really wanted to focus on what did happen and what could happen next, and what has been invited to happen next by the judge in what will now go down in history as the famous footnote 8 that I'll let Karen talk more about. Karen, what do you think?
So this was interesting because so far I have been impressed with Judge McAfee so far. And I think a lot of people were a little bit skeptical because he's so junior and so green as a judge. And he's been a decent judge so far. in this case, even though he's obviously a Republican appointee, et cetera. And he's made some pretty fair rulings up until the Fani Willis disqualification hearing. There, I think his inexperience really showed, because he let the hearing become very undisciplined, out of control, and had a lot of irrelevant information come out, and at the same time have almost none of the relevant, potentially disqualifying information to come in. So that was the first kind of raise one eyebrow about Judge McAfee. And then this decision, I think, is raising the second eyebrow. I just disagree with his decision, but let's talk about it a little bit and talk about what he says and what he does. So essentially, Trump and Giuliani, just to put it, kind of give context, we used to be facing 13 charges each. Now they're only facing 10 charges each. And it also reduced the number of charges for some other defendants, Meadows, Eastman in particular. This decision dismissing 6 of the counts doesn't weaken the case in any way. And the evidence still gets to come in so one of the substantive counts that was dismissed was about this famous call to Brad Raffensperger, the find me the whatever number of votes it was, call. So that substantive charge is no longer a charge, but it is an overt act in the RICO case. So it still will come in. The evidence will come in. But what he found was that 6 of the counts had to be dismissed because they were overly broad and too vague, and that indictments are really, for the purposes of double jeopardy in particular, need to put defendant on notice of what they're being charged with and what they're going to be convicted of, so that someday in the future you can't be tried again for the same conduct. Now, I think it's very clear that this is specific. I don't agree with his interpretation here. And 5 of the 6 charges that he dismissed have to do with charges about violating the oath of office, right? It was five violations of oath of office plus the famous phone call. And the reason he found this lack of particularity or specificity that he claims did not inform the defense with sufficient detail of what they were doing was they didn't mention which oath of office they were required to take. They didn't, or which, was it the state or the federal oath of office? When you swear and say, I promise to, it's kind of like the Trump defense. Oh, I wasn't swearing to uphold the Constitution. It's just ridiculous, right? Which oath to take. But then he said, okay, but the indictment does say which oath. Okay. It does say, that it was, the federal and state oath, that it was both, right? So the indictment does specify it, but what he says is, but they don't say which term in the oath is alleged to violate. And the reason I think it's wrong is they're not charged with violating the oath of office. They're charged with solicitation, right? They're trying to solicit someone to violate their oath. They're trying to get them to violate their oath. I'm sure they weren't, the thing that bothers me about that is it's kind of like what's happening in the Bragg case, this argument that, well, we don't know which crime, the bump up to falsifying of business records requires there to be an intent to commit a crime there. And which crime? We don't know what's in the person's brain. We don't know which crime you were going to commit necessarily. We think it was either tax fraud or election violation. We know it was, you were trying to commit a crime, but I can't tell you, was it this one or that one, right? I'm not in your head. And the same thing with solicitation. You're trying to get them to violate their oath of office. And if I'm the person soliciting you to try to get you to violate your oath of office and by putting in fake electoral votes, right? I don't care if you violate the I promise to uphold the Constitution and do it, or, whichever one you feel more comfortable, Mr. Criminal. If you feel more comfortable saying, okay, I'm going to violate the state constitution instead of the federal constitution, I'll take it, right? I don't care which oath of office you violate. Just, I want you to violate an oath of office. And so you're trying to get them to do that. That's very different than proving that he did it. And because if you're going to charge someone with doing something, you have to prove that. But if you're trying to get them to commit a crime, right, and you don't care, you're sort of agnostic if it's this one or that one or the other one, you just want the result, right? And to get to the result, you have to violate one of those oaths of office. Then to me, that's enough. But McAfee doesn't basically doesn't allow that. And so I just don't get it. I don't really get it. Anyway, so he basically also talks about how, he uses the word generic, that to say you're violating your oath of office, that's just too generic. Okay, I don't know. That's where you feel like you're in bizarro MAGA world. Everybody knows what that is, and I don't think that's vague or going to implicate double jeopardy, because one day you could be prosecuted for the same conduct for violating a different constitutional oath. I mean, it just makes no sense to me.
Let's do it a different way. I agree with you. Let's do it a different way. Theft of honest service, which is another type of crime. Or when the reason that Donald Trump called Brad Raffensperger is not because he was Citizen Raffensperger. He called Brad Raffensperger because he's the Secretary of State of the state of Georgia with power and authority over certain electoral functions of the state, including certifying the election. Right? He didn't just call a random person, just going to go to the old phone book and go, I'll call this guy and complain. He called a person that held an office, who took an oath of office, as they all have to uphold the integrity of the office. I mean, you can go through, for Scott McAfee to say there's so many things in a U.S. Constitution. How are they supposed to know which ones they're okay? The oath of office is a concept of fair and honest service, a public service. And when you're trying to corrupt that, as has been adequately alleged in 100 pages of the indictment, including 161 overt acts, I think you can put two and two together, and that's fair notice for due process purposes to the criminal defendant. What do you think? What did you think of, particularly, Karen? Let me just talk about footnote 8. So as we wrap up this particular provision, so in the footnote, the judge anticipated and invited that there be further litigation over this issue. He gave the prosecutor, whoever that may be, two choices. They can, within 6 months from the date of the order, which is 6 months from today, they can try to get a superseding indictment in Georgia, I assume by re-impaneling, although he says future grand jurors. Yeah, okay. Let's see, barring future, even if the statute of limitations has expired, the state receives a 6-month extension from the date of this order to resubmit the case to a grand jury. And it's interesting. He also said in there that those grand jurors may not be publicly accessible as to their identity, which is interesting because he does know what happened with the last set of grand jurors under Georgia law, which required them to sign the indictment, and that indictment got out and they all got doxxed by MAGA and by Trumpers. He's basically saying, I got you on this one. You want to get a superseding indictment within the next 6 months? And you get it, and you clear up this couple of issues that I think you have with this element of the crime, then I may actually grant the or whoever would grant it the permission to redact the names of the grand jurors. Don't worry about that. If she doesn't want to do that, he's also giving her the right, with an immediate certification on his end, to take an appeal to which I assume would go to one level of appeal over Atlanta, and then in Fulton County, and then up to the Georgia Supreme Court. So he knows that she's not going to be happy with this. The question I have for you as well is going to be is whether this means anything. Should we take anything from the fact that he did not dismiss the entire indictment, despite the fact they asked for that in the motion to disqualify Fani Willis? Not doing that, apparently. And should we take anything, any comfort, cold or otherwise, from this order to expect something one way or the other on tomorrow or Friday about Fani Willis's continued involvement in this case? What do you think?
I've been asking my friends, what do they think? What tea leaves do they read from this? What does it mean, right? Is he going to dismiss? Is he going to remove the case? Why would he have done this? If he's going to remove the case, why would he have not done this? So I honestly don't know. This one perplexes me a little bit. I think it's a good idea. I think it's good that he's still doing this, that he's still making rulings about this case with Fani Willis. I think in my head, I want to believe that if he was going to disqualify her, he would wait until a different prosecutor was on the case and then do this. Or maybe he's just trying to wrap all this up. But, if he's already made a determination that she's not qualified, that there's a conflict of interest, how could he be making rulings about her case? I don't know. I'm trying to read the tea leaves, but I'll be honest, I don't know here. I really don't know. I'm a little worried, having gone down the rabbit hole of watching almost the entirety of those conflict of interest hearings, that they clearly did not establish a conflict of interest. They just didn't meet their burden. However, the judge was very interested in the concept of when there's an appearance of a conflict of interest, that sometimes can be disqualifying as much as an actual conflict. And there is an appearance of conflict of interest here, because the MAGA right-wing Republicans and the defendants, and frankly, Judge McAfee, by allowing in all this extraneous, ridiculous evidence about a consensual adult relationship and all the other stuff we had to hear about, that there potentially he could find an appearance of a conflict. So that is the only thing that worries me, having watched the hearings. What happens here, though, next, if she does not get disqualified? I think she has a few choices, right? She can either go back into the grand jury and supersede the indictment. Shouldn't take very long. Should happen actually quite quickly. But then that'll reset the whole motion practice. It definitely delays things, because then they get to make motions on the new indictment and they get to review it, and it just delays things. Or the other thing she does is she lets it go and just says, fine, I don't care. I still get to use the evidence, so I don't have these substantive charges. Or the third thing is she could appeal it. And again, that would just delay things. I think if she appealed, I don't know. I think the law is clear that he's wrong. I shouldn't say the law is clear. I think there is a chance that he's wrong. And so I think she has a chance of winning. But so who knows what she's going to do? But those, I think, are her main choices. And I'm sure they are trying to determine right now exactly which way to go here.
All right, well, welcome back. That was Legal AF. We pulled together and curate the best 5 stories during the week at the intersection of law, politics, and justice. And we bring it to you and break it down for you just like that. The show's called Legal AF, that cheekily named show at the intersection of law, politics, and justice. And we do it one place right here. Don't change that dial. The MeidasTouch Network. We do it on Wednesdays. We do it on Saturdays at 8 p.m. Eastern time, and then on audio podcast platforms of your choice. So if you like law and politics shows led by lawyers who know what they're talking about, you've come to the right place. Free subscribe to the MeidasTouch Network. Help them get to 3 million free subscribers before the November election. So if you know about Legal AF, you're already part of the audience and you've been there for the hour-long podcast, we appreciate you. Can't tell you how much. If you have, you could always, by the way, take that clip. Well, that's why we do the clips. Send that segment to somebody in your life and say, that show I love, Legal AF. Here's an example. Maybe they'll join our audience in our long format podcast. If you have no idea what I'm talking about or who I am, that was Legal AF. I'm Michael Popok. And we invite you to be part of our audience on Legal AF. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.